is 25-14161FH. And in that file, appearances, please.
Good morning, Your Honor. Abigail McIntyre appearing on behalf of the people, P71143.
Good morning, Your Honor. Lisa Kirsch-Satala appearing on behalf of Mr. Allen, who is present.
Thank you. Sir, you may be seated. Now, looking to the next file, People of the State of Michigan versus Wesley and Connor. This is file number 25-14162FH.
Good morning again, Your Honor. Abigail McIntyre appearing on behalf of the people.
All right. Who is the defense?
I'm Jeff Harrison. I'm here on behalf of Miss Connor. As the court will note, she is not physically present. She is present by Zoom. I had a conversation with her this morning. She was in the hospital last night with some kind of sepsis related infection.
I got it. I don't need to know what.
No,
Thank
there's
you.
No objection for the people that should.
All right.
Thank you.
Thank you. All right, so we're here today. Set for a final pretrial conference. It is. And I know we have a trial date set in about a couple weeks. We have a motion here. Let's go ahead and take care of the motion. The motion is to adjourn the trial in the Christopher Allen file.
It's for the both.
And for Ann Wesley Connor. Do we have them joined together for one trial? Do we?
We do, Your Honor.
No.
I don't know if Miss Satawa is going to be filing a motion to sever.
Okay. All right.
But that hasn't been filed yet, to my knowledge.
All right. So
I actually have a draft with me, but so it'll
we
be.
can make it orally, so we'll talk about that, or but we'll see if we need to raise that up first. Then I also saw that there was an intent for 76827B information, and that was filed in the Wesley and Connor file.
That's correct.
Does that apply to both?
No, just applies to Miss Connor.
Thank you. All right, so let's deal with the people's motion to adjourn the trial date.
Well, Your Honor, this is the second time that the people have brought it before the court. The first time the court informed the people that it was a premature motion, because I informed the court that I was double booked. I am booked to be in a trial on March 11th in the suit. That is also a capital case, which we scheduled back, I believe, in October. As far as today goes, we received a notice from the court in the Sioux that we are still on the docket, ready to go.
And that's why I don't like motions to adjourn until I know it's really gonna go to trial. And I often call the other judges and say, hey, judge, is this one really likely to go to trial? Give me your input. So I'd like to wait till we get to the end, because I don't want to adjourn and lose a trial date here in our courts. All right. And in that case, you said capital, is the defendant still in confinement?
He is on house arrest and tether.
Okay.
It is an older case. It's two counts of CSD first, incapacitated individual, and one count of CSD third.
Okay.
There's been no offers, so
All right.
requested were made at this point. So it's my feeling that it's gonna go.
All right. Our trial here is set for March 10th. Is that correct, Madam Clerk?
Yeah.
All right, Ms. Satawa, your response to the motion to adjourn?
We have no objection to the request to adjourn. We have been in the process of getting our experts report. It has not been, we don't have it yet, and we have obviously not been able to turn it over to the people. In addition to that, we have been having some fruitful discussions, and so we're hoping for more time.
All right, sounds good. Thank you. Well, again, it wasn't intended to be rude when I denied the stipulated request. It's just because I want to make sure I keep cases moving. This also gives me the opportunity to talk to the defendants in person and hear from the judge. My goal is to get the case moving, get the case done. However, when there is a reasonable good cause request to adjourn a trial, then I'll grant it. There are also things that put other cases forward versus others. And since neither you or Ms. Connors are in pretrial custody, your case is not the top. So I'm going to go ahead and grant the motion to adjourn. We'll have it reset on the trial docket. There will be another final pretrial conference. All right, so to both Mr. I always want to, there's another case that has a very similar name, and I don't want to call you that person's name, and Mr. Allen. So Mr. Allen and Ms. Connor, when I have final pretrial conferences, final pretrial conferences are the last date in which we're going to take, or I will allow an acceptance of a plea underneath the pretrial agreement. And then if we don't have one on a final pretrial conference date, then the case is going to trial. The only thing I'd let you do is plead straight up on the trial date. Now, please know, Mr. Allen and Ms. Connor, that is not to force anybody to enter into a pretrial agreement. In fact, my policy, I think, helps defendants just as much as it does me. You want to know on that day, is the offer going to get any better? And the answer is no. I don't want you waiting till the very last minute, freaking out and, oh my gosh, am I going to get this? You know, on that day, that's the best offer that people are going to give to you. And also because there are a lot of things that have to happen in the background. You have to have about 120 potential jurors come in. They all have to rearrange their schedules, get somebody to pick up mom, take grandma to the hospital, take care of the kids, get somebody to stay home from work so the other spouse can come, and all that. Plus subpoenas have to be issued, witnesses have to be brought here, and there's a lot of moving parts. So before I make those parts move, I tell the attorneys, make sure you have exhausted all your brilliant negotiating skills and tactics. That again, not only helps you, but also helps the court. And on average, I can do about 24 trials in a given year covering 2 counties with circuit court criminal cases. And if I were to allow deals on the trial date, I'd lose the opportunity to do a trial. And therefore, the people of Wexford and Missaukee County lose a trial date too. So please know, I don't know anything else about the file other than the charges. I have no opinions about what you should do or how the case should resolve. I'm just here. I run Tiger Stadium, also known as the Circuit Court, and I want to watch somebody play baseball that day. Okay, which is always the funniest analogy for me to give because I cannot stand baseball. All right, thank you. All right, so on that file, we've covered the motions to adjourn. There is something else, and do you want to talk about joinder or severance, or do you think you want to put together a written motion to put it all together in a better package? I don't particularly care.
I mean, I can argue it off of my draft if the court wants to hear it.
But it all, and now that means I turn to Ms. McIntyre and say, because I know you have the right to have notice. So
Your Honor, honestly, it would be my preference if it were written, and so I have an opportunity to respond.
yeah, sure, I don't
And
know.
I mean, depending on what she says, I don't know what my answer is gonna be. I mean,
Okay.
Ms. Satawa could make a, really brilliant argument, and I could say, makes sense. So,
Well, if there's anyone who can, it's probably Ms. Satawa.
so I would prefer written, Your
No
Honor.
problem, that's fine. And who knows, maybe in the preparation of that and exchanges, you all might go, oh my gosh, that makes sense, or maybe it'll help resolve the case. So it's probably best that I don't address it now. But I wanted to make sure that the counsel, the attorneys, and that's right, parties that heard us talk about that a little bit. Again, I think it's the first time I've met you, Ms. Connor and Mr. Allen. Maybe I'm wrong, but I think it is. If I haven't, that's a good thing if I don't recognize you. All right, anything else you think we need to address, Ms. Satawa, today?
No, Your Honor.
All right, Mr. Harrison, on your file?
I'm fine as well, Your Honor.
All right, thank you. I forgot to ask you, Ms. Connor, are you able to see and hear us today?
Yes, Your Honor.
Hey, I don't want to turn this way since you're signing. All right, Ms. Connor, hope you're feeling better. We'll see you all in a couple weeks whenever I get a new docket schedule. Anything else, Ms. McIntyre?
Your Honor, just for clarification, because I'm a rookie in front of your court, so the court is gonna give us another pre-trial date without a jury trial date. The jury trial date will be determined at that pre-trial date.
Nope,
You get a-
you will get both. You'll get a date for both.
Okay,
And then we'll deal with, potential adjournment, things like that if we need it.
potential conflicts again.
Yeah, it'll probably, you won't be back here till at least probably a month for a final pretrial date on a Friday.
Okay, I just was wondering in terms of a trial date, like if there can be, well, I don't know how the court schedules it, if there's like emails that go out and say, do these dates work? Because I know there's other trials that have been scheduled and I also
Yeah.
have some medical issues going on that have to be dealt with, so.
Okay. All right, well, the answer is I just pick dates.
Okay. Yeah,
Because if I ever try to coordinate dates,
I know it's a circus.
and especially, and I see it with my civil cases,
Yeah.
it takes forever and I'm just not going to do it.
Okay, fair enough.
Yes, ma'am.
I am 100% not available from April 28th to May 13th.
Maybe,
I can send an
Okay.
email.
yeah,
and
just do that to Nicole.
Cool.
Nicole's the one that handles that. So that's perfectly fine.
Okay,
Going someplace fun?
South Africa.
Oh, well, can we all go?
I don't know. Well, anyway, that's fair and reasonable, but if you guys have a good excuse, that's fine. And again, if I just keep the things going, sometimes a case resolves and I keep you all thinking about it. I do not like cases slipping on to the back burner. And I know you both or you all are quite busy. So we'll see, we'll deal with it. Send a message to Nicole.
Okay.
And she'll take that in consideration,
Okay.
setting it out. And as long as there's no
Bless
objection.
you.
All right, thank you, folks.
Thank you, Judge.
We're
Yes,
adjourned.
Judge.
Here we go. All right, folks, good morning. And we are on the record today now for the 28th Circuit Court, and we're taking up this case here of people of the state of Michigan versus William Forrest Manicky. And this is file number 25-14058 FH. Appearances, please.
Nick Hearns on behalf of.
And I'm Jeff Harrison. I'm here on behalf of Mr. Manicki. That is him on the video screen appearing from the jail.
Mr. Manicky, are you able to see and hear the court?
Yes, sir.
All right. Also before the court is Mr. Stephen Saladay, an agent from the Michigan Department of Corrections, serving as the probation officer here today. We are here today for an arraignment on a requested warrant for a probation violation. Like there had been a previous show cause. Hold on. There was a request and summons for a probation violation that was filed on January 21st. The court ordered the defendant to appear on February 5th. Failure to appear, a question warrant was filed. However, before we he did appear. I'm sorry. And then I released him on a PR and then failed to appear on February 9th. Thank you very much. All right. So, Mr. Manicki, we're here today for this probation violation hearing. I still think I need to advise you. There's an amended charge, Mr. Saladay? No?
Okay.
Make it a requesting warrant with the same charges.
Yes.
All right, thank you. So, Mr. Manicki, we're still facing 4 counts for violating your alleged terms and allegedly violating the terms and conditions of your probation. Again, count 1 is that you were not in your approved residence between curfew hours of 10 p.m. and 6 a.m. on January 7th of 2026. Also, that for count 2 that you consumed alcohol on that same date. For count 3, you failed to appear for your show's cause hearing on, so we did have the count, on February 9th of 2025. Okay. So that's a new added count. And then also you had count 4 that you actually committed disorderly conduct on or about January 7th of 2026. Mr. Harrison, what are we doing today?
I would like the opportunity for an informal. If that's not available, I believe I had some preliminary discussions with Mr. Saladay, but in the interim, I was unable to locate Mr. Manicki and they never proceeded beyond that.
Okay. Um,
I can do that.
Well, let's see what, how many final pretrial conferences are yours this morning?
Three.
Three? All right,
Then there's the motion in the AG's case,
all right,
and I believe 2 pleas, but
okay. All right, well, first of all, Mr. Manicki, again, I've gone over those 4 counts. I need to tell you once again that, as I told you before, you have the right to challenge not just the first 3, but also now all 4 alleged violations of violating your probation. You have the right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to be represented by counsel at the hearing, as well as any subsequent proceeding. Also, the right to question and cross-examine any witnesses against you, and the right to present witness evidence for testimony if you choose, and also the right to remain silent and not have that silence used against you. If you're found to be in violation of your terms and conditions of probation, you would be resentenced on your original offense. Was this resolved with a UDAA or the unlawful use version?
Unlawful use, Your Honor.
All right, so that's the misdemeanor,
yes.
and that's punishable by. Oh, there we go. It didn't get tagged. It's actually a high court misdemeanor punishable by up to 2 years, $1,500 plus suspension of the defendant's driver's license. And based upon the fact that there's at least 1 non-technical, the court is not limited to a sliding scale. All right, thank you. The court will adjourn the day, have it set for an informal hearing. Now, to do that, since today it starts 14 days, again, because I had to re-advise them of the
I
count 3.
will happily make a preemptive waiver of the 14 days due primarily to my unavailability in the first part of next week.
No problem, I
I
understand.
don't want to lop over a date just because I'm in a trial.
I'm in a trial too. So.
Yeah.
All right. The court will continue the not guilty plea. The court will continue to have it set for an informal hearing. Anything else to hear from Mr. Carnes?
Your Honor, I would just ask that the court remand the defendant pending the hearing given to.
Oh, that goes without saying. All right, Mr. Harris, unless you want to, you get the right to make an argument. Maybe there's something I don't know out there. Maybe he was working special forces someplace I don't know.
No, at this juncture, I believe that a remand actually makes sense.
All right, thank you. The court's going to deny the defendant's bond and remand him into the custody of the Washington County Jail pending that informal hearing, which will be within maybe the next week, if not within the next 2 weeks. Thank you.
Thank you, Your Honor.
We are adjourned.